back. I'm Mark Jensen. Former stockbroker Mark Jensen back in court after nearly 15 years to once again try and prove his innocence. Jensen is accused of poisoning his wife Julie with antifreeze and then suffocating her in their bedroom back in 1998. In a letter that she wrote days prior to her death, she gave it to a neighbor. She basically said that Mark, her husband, was trying to kill her. Well, that letter, it played a major role in the 2008 conviction. This new jury number 2, not going to see the letter, not this time around. But will it make a difference in their decision? That's the big question, right? Before we get you back into court, let's bring in the guests to talk about it. We have attorneys with us standing by, Elizabeth C.J. Baker and Gabriel Sepulveda Sanchez. Elizabeth, to you first. You know, a lot of people talking about this on Twitter. I'm sure your handles are blowing up. We have Patty Ross writing, I don't get why the letter can't be in evidence this time around, but those videos of dead or ill people who testified in the first trial can. Explain it to me.
The letter's not admissible because essentially the court ruled it was an out-of-court statement. You know, it's Crawford versus Washington prohibited testimonial hearsay. The tapes regarding previous testimony are admissible because the parties both called the witness, they both cross-examined or did direct examination, so the witnesses had an opportunity while being fully, examined by all parties in order to testify. So the testimony is preserved. The testimony would exist whether they were playing it for this jury or whether it would be used for impeachment purposes. It's just a different caliber of testimony. A letter not subject to cross-examination or confrontation, prior testimony under the rules subject to prior confrontation. All
right, Elizabeth. And now, Gabriel, you're up there in Los Angeles with a follow-up question from Dee Dee Haggerty, who was basically saying, okay, so they can play the video, but this second defense team, they can't cross-examine. So how do you combat that?
You know, I think it's one of those, how do you combat they can't cross-examine? I mean, I'm pretty sure they feel confident in the first. It looks like there was a very thorough cross-examination already, and I think there's also probably going to be an instruction. I'm sure there is instruction by the judge that really strict to the jury that, hey, listen, you're only considering his testimony. You're not to consider the contents of that letter as evidence against the defendant. So I think the judge has a good instruction to protect the defendant's rights. And it looks to me like this is, a very thorough cross-examination. So I'm sure, they got to work with what they have. Unfortunately, the officer's passed away now, and they can't, have further cross-examination on it. So this is how it's going to be. And I think at the end of the day, the chips fall where they are. So they have to just let this go. I'm sure they would like to follow up with some more cross-examination, but they can't. And it seems like it's a very thorough cross-examination by the defense. I think the main issue here is that letter not being admissible into evidence. So I think they have some stuff going for them right now.
The big question is he going to take the stand, right? Don't answer just yet. We'll get your response, but we're going to head back into court right now.